General, what's the problem you're getting at? Is it the employer not providing, making sure that employees are vaccinated or masked, or is it the employees who decline to be vaccinated or masked?
Well, it's the grave danger to exposure to COVID-19 at work, Justice Thomas.
Who refuses to do that?
Ultimately, what the agency is doing with these standards is requiring that either through a vaccination requirement or through a masking and testing policy, that unvaccinated workers who stand the highest chance of contracting the virus at work, of infecting others at work, and then ultimately if they get if they catch COVID at work, of then suffering death possibly or even hospitalization, are protected in all of those circumstances. So I think what this standard does is it regulates employers by requiring them to adopt a policy that will directly target that grave danger.
I understand that, but who is declining to do that? Is it the employer or the employee?
I think it can be both. There are many employers around the country that have voluntarily imposed these kinds of requirements with their workers in recognition that vaccination is the single most effective way to protect workers in the workplace, or that have used masking and testing requirements to the same end. So many employers are doing it, but part of OSHA's function and what Congress charged the agency with doing is to look at those kinds of best practices and impose them through standards to ensure that workers, no matter what specific controls their employers have in place, are maximally protected.
One last question. I think you put quite a bit of weight on the acute crisis that we're in. But would your argument be the same for any infectious disease that is taken into the workplace?
No, I think that with respect to other infectious diseases, it would be necessary for OSHA to develop the record to demonstrate that the requisite risk level that the statute requires is satisfied.
It's not that you would do it, but could you do it?
If there were, in fact, a grave danger to employees posed by another infectious disease, then yes, we think that Congress clearly contemplated that OSHA is obligated and charged with the responsibility.
Has OSHA ever done that?
OSHA has enacted any number of standards that address those kinds of threats. For example, the bloodborne pathogen standard that we have pointed to before was intended to protect employees from the risk of viruses that they can contract through bloodborne transmission. So
is that in the general workplace or just in healthcare?
That standard applied anywhere where employees can predictably encounter bloodborne pathogens. So it wasn't just the healthcare context. It can apply to flight attendants. It can apply to janitors. It was a standard that directly targeted the exposure wherever it exists, just like this one does.
Thank you.
General, you said just a...
Counsel, would you discuss the preemption issue just briefly?
Yes, Your Honor. This regulation, the Secretary says in this regulation that it is intended to preempt arguably any inconsistent state laws with respect to vaccination requirements. And for example, in this case, the most direct example I can point to, Your Honor, is at 20-7-134 of the Arkansas Code that prohibits as a condition of employment any sort of vaccination requirement.
But that's somewhat ironic since the government relies on those other vaccinations to argue for this vaccination. But are all of the party states in the same position with respect to preemption?
Your Honor, certainly the district court in this case, at the very least, cited that Arkansas, Wyoming, and Missouri are similarly situated with that respect, and certainly there are other states in the Missouri-led coalition that also have laws that are going to be preempted by this regulation. The key point here, Your Honor, just like in Mass VPA, is so long as one of us has one of these laws that would affect our duly enacted legislation through an unlawful mandate, it does present an issue on preemption. Now, that's independent, obviously, from other interests that the states have in this case, which is the states are the administrator. It's our providers with respect to Medicaid. With Medicare, we're being asked to facilitate this program for the federal government. We have compliance costs. We have surveyors who have to go out and enforce this rule. All of that are the state's interests, Your Honor.
Well, the one final point has to go to standing. You seem to rely on parens patriae a bit. And would you discuss that standing and why we should apply that?
Well, sure, Your Honor. And just to be clear, we do have various capacities here. We mentioned sovereign interest, we mentioned proprietary, a whole plethora of them. And certainly we did invoke also a quasi-sovereign interest in the health and well-being of our citizens. For example, this mandate will close the doors of many of these rural facilities that will effectively deprive our citizens of health care. And we also are asserting rights under federal law with respect to the APA on many of these claims. But that is not the only basis that we're seeking standing in this case. We have various other capacities that we're suing under, just like the ones I mentioned, Your Honor.
Is that true of all of the parties?
I believe so, Your Honor, yes.
Thank you.
There was a question. Sorry, Chief.
No, I was just going to ask you about the spending clause context. In other words, we're not just dealing with federal law in the abstract. We're dealing with a provision that says Congress authorized, the Secretary to ensure compliance with requirements that the
Mr. Flowers, there's been some suggestion, or at least it seems to be implied, that the vaccinations are efficacious in preventing some degree of infection to others. Could you talk about that, particularly as I remember in the filings, that the that the younger workers, the 20-year-olds who are unvaccinated are actually safer than the older workers who are vaccinated. So there are obviously some differences. Would you just talk about how efficacious the vaccine is in the workplace?
First, I want to be very clear. We are strong promoters of vaccination because they do stop serious illness. In terms of stopping infection and transmission, at least with the current variant, it appears, as the numbers suggest, to be far less effective. And then in terms of the comparison you were asking about, I think it's hard to define what's a grave danger in the abstract. What we can at least mandate, or at least demand from the agency, is internal consistency. And if you look at their own data, the CDC data from the last week of October, unvaccinated individuals 18 to 29 were as likely to die as vaccinated 50 to 64-year-olds, and 5 times less likely to die than vaccinated 65 and up. Hospitalization was between 18 and 49, that's not even just the young, was about as likely as vaccinated 65 and up. If you look at the Griffin study that they cite at 61,418 of the Federal Register, unvaccinated and vaccinated both had low risks of death in ICU. As a societal matter, we are not debating that COVID is serious, and it is an incredibly grave risk for some people, not for everybody. And finally, I'd point you to the Scobie study. Again, they cite that 61,418 of the Federal Register says that vaccinated individuals who are 65 or older are twice as likely to die as unvaccinated individuals 18 to 49. And keep in mind that's 18 to 49, not 18 to 29. So it would probably be even more skewed if you looked at the younger demographic.
Would the state of Ohio have I'm not saying this would be an approach you would take, but you had earlier a discussion about whether or not the federal government had police powers in the workforce, and you suggested that the state has those police powers. Could the state of Ohio do what you say OSHA cannot do?
In terms of, yes, my position is the state of Ohio, at least, could mandate vaccinations not only for workers, but for all individuals. Now, I think that's an important point to stress, as we're talking here as though OSHA is the only entity that can regulate this, an agency that no one thought had anything to do with the pandemic until months, if not years into it. But we have the states and we have private businesses, and they're not sitting on their hands. And individuals are doing things to try and bring this pandemic to a close, or at least learn to live with it. Indeed, this court, without any requirement from OSHA, has found ways to safely conduct business.
I think my point is rather that there seems to be a suggestion that this is all or nothing, that the other governmental bodies do not have police powers to regulate certain activities. And you've answered my question. Thank you.
Justice Breyer?
Quick question. I'm just curious. I was searching for an example. Universal risk inside and outside the workplace, including the workplace. Can OSHA regulate it? Can OSHA regulate fire risks?
Yes, we don't draw the distinction between.
If they can regulate fire risks, then why can't they regulate this risk?
Because the difference with the fire is that there's something about the workplace. For example, not providing safety equipment to put out the fire.
People throw matches. They smoke sometimes. Oh, they shouldn't, but they do. Or they throw a match. Or they, a lot of causes, such as crushing.
Mr. Hinojosa, if this were a Title VI case and there was an allegation of discrimination against the University of North Carolina, who would bear the burden of coming forward?
Is it within the strict scrutiny?
No, just Title VI claim of discrimination.
A normal claim of intentional discrimination,
Exactly.
Your Honor. I would understand that the plaintiff would have that burden to demonstrate.
To come forward initially, but then when the plaintiff makes his or her showing, then what? What's the duty of what's the burden on the accused?
Well, it's not entirely clear from the case law that I'm aware of, Your Honor. Ordinarily,
Is there any case where the court has deferred to the university or to the alleged discriminators' policies?
So, for example, I don't know whether or not this has been answered directly in Title VI case law. Title VII case law, yeah. Your Honor, yes, then the burden would shift to, in that case, it might be the employer.
What's interesting here is I cannot think of another area or another case where the court deferred to the alleged discriminator on something as important as compelling interest. We don't do it in Title VI. We don't do it in Title VII. You have McDonnell Douglas. You have Arlington Heights. And this is a first. And what I'm asking you is, isn't it odd that you have a framework in Grutter that defers on the critical issue in the case of compelling interest?
No, Your Honor. I think it's entirely consistent, with this case, with this court's framework in judging strict scrutiny. Let me make a couple of points first. One is on the discrimination point. This is not discrimination per se. The limited consideration of race in a holistic fashion, as this court has approved, is a limited classification that is subject to strict scrutiny, but that whole strict scrutiny process is trying to filter out whether or not we have a legitimate purpose for this or not, and whether or not there's a compelling interest that may be sought and achieved, through narrowly tailored means.
Let me ask more specifically. If this case involved a school district in Virginia in 1960 that is alleged to be discriminating, would this court defer to its assertion that the races do better if they're segregated?
Absolutely not, Your Honor, but that's not this case. This case is about a limited classification involving a compelling interest.
That's not what I'm talking about. I'm talking about the court's deference. In that case, the court would put Virginia to the test. In this case, it does not. And I'm asking you why the difference.
In this case, Your Honor, it actually is. The burden is the university has a high burden of demonstrating its compliance with this court's standard under strict scrutiny. The only narrow area that this court's framework, as I understand it, has deferred to the university is establishing its objectives. But the whole framework still requires a well-reasoned explanation for seeking for its own compelling interest. It requires the university to demonstrate that there are no race-neutral alternatives that will work about as well. And so that burden is still heavy on the university to demonstrate compliance with this strict scrutiny framework.
Questions?
Mr. Park, I've heard the word diversity quite a few times, and I don't have a clue what it means. It seems to mean everything for everyone. And I'd like you first, you did give some examples in your opening remarks, but I'd like you to give us a specific definition of diversity in the context of the University of North Carolina. And I'd also like you to give us a clear idea of exactly what the educational benefits of diversity at the University of North Carolina would be.
Yes, Your Honor. So first, we define diversity the way this court has in its court's precedents, which means a broadly diverse set of criteria that extends to all different backgrounds and perspectives and not solely limited to race. And there's a factual finding in this record, PEDAP 113, that there are many different diversity factors that are considered as a greater factor in our admissions process than race. We have a particular interest in recruiting and enrolling rural North Carolinians. In the last incoming class, 4 out of every 10 students who entered the campus doors were from rural North Carolina. 1 out of every 12 students has a military affiliation, including the most veterans on campus since World War II. And so we value diversity of all different kinds and all the ways that people differ in our society. On the educational benefits question, Your Honor, I don't think it's actually disputed here that there are real and meaningful educational benefits that come with diversity of all kinds. SFFA's own expert, this is on JA 546, conceded and agreed enthusiastically, in fact, on the stand, that a racially diverse and a diversity of all kinds leads to, quote, a deeper and richer learning environment, leads to more creative thinking and exchange of ideas, and critically reduced bias between people of different backgrounds and not solely different racial backgrounds.
But you still haven't given me the educational benefits. I didn't go to racially diverse schools, but there were educational benefits. And I'd like you to tell me expressly, when a parent sends a kid to college, that they don't necessarily send them there to have fun or feel good or anything like that. They send them there to learn physics or chemistry or whatever they're studying. So tell me what the educational benefits are.
So there's 3 main buckets, Your Honor, and the first, and I think most pertinent to the question that you asked, is the actual truth-seeking function of learning in a diverse environment. I would direct the court to the Major American Businesses brief, which discusses a whole extensive, rigorous, peer-reviewed literature that diverse groups of people actually perform at a higher level. So the most concrete possible scenario is stock trading. And there are studies that find that racially diverse groups of people making trading decisions perform at a higher level, make more efficient trading decisions. And the mechanism there is that it reduces groupthink, and people have longer and more sustained disagreement, and that leads to a more efficient outcome.
Well, I guess I don't put much stock in that because I've heard similar arguments in favor of segregation too. I'd like to go to something different, to deference. In the area of a compelling interest. This court in Grutter did not specifically put the test to Michigan as far as diversity being a compelling interest. I'd like you to explain why in this area of strict scrutiny we have a lower standards. We defer to the accused discriminator, but in the instance of sex discrimination at VMI, the accused discriminator was put to the test, and the court did not defer to VMI, but it deferred to Michigan. Why that difference, and why should you not be treated the way we would treat someone in a Title VII case or a Title VI case, and shift the burden to the discriminator to explain the conduct?
Our understanding of the deference that this court provides and the deference that we request is quite limited, Your Honor. We ask for deference in terms of our educational objectives and not the legal question of whether those objectives constitute a compelling interest. And I think that it's pretty clear to see why. I think that is similar to the VMI context. So like I mentioned, we have made it a system-wide priority to
the court did not defer in VMI.
So I think it did to the extent that it held that the interest in a rigorous military education is an interest that the institution had. And so if UNC decided at a system-wide level to say we're going to completely change our educational mission and make it into an institution like VMI, I think the compelling interest analysis would proceed with that educational objective in mind. But we do not take the position that the compelling interest standard is somehow subject to deference. That's a legal question.
Mr. Chief Justice, and may it please the Court. The Bank Secrecy Act authorizes the Secretary of the Treasury to assess a separate civil penalty for each foreign financial account that a U.S. person fails to report. Petitioner violated the Act 272 times, not just 5 times, when he failed to report dozens of foreign financial accounts in each of 5 years. That understanding of the statutory scheme flows straightforwardly from the text. As Justice Kagan illustrated this morning, Section 5321A5 sets up a one-to-one correspondence in which each undisclosed account is a separate violation. We know that because the rules in Section 5321A5 for determining the maximum penalty for a given violation involving an undisclosed account turn on the balance in that particular account. Petitioner's reliance on the Dictionary Act is therefore misplaced. The background rules in that act don't apply if the context of a particular statute indicates otherwise. Here, the text of Section 5321A5 demonstrates that Congress used the singular precisely and with care to establish a one-to-one relationship, the relationship I just described. One account, one violation, one potential civil penalty. Reading the statute's references to a single account to mean one or more accounts would defeat Congress's deliberate design. And there is a good reason that Congress set the penalty scheme up this way. Each time a U.S. person maintains an account with a foreign bank, that relationship is a matter of distinct concern to the United States. That is why the text of Section 5314 directs the Secretary to adopt record-keeping and reporting requirements that capture account-specific information, such as the account number. When a U.S. person fails to report multiple qualifying accounts, the person violates Section 5314 multiple times. And that remains true even if the Secretary permits the required reports about each account to be consolidated on a single annual form. I welcome the Court's questions.
One of the things that seemed problematic to me is you cite 5314, but it doesn't mention accounts.
Well, Justice Thomas, Section 5314 is phrased in terms of filing reports and keeping records about a relation between a U.S. person and a foreign financial institution. The relation the statute is discussing is an account relationship. And
well,
so
it doesn't say that, though.
It's true that it does not use the precise word account, but we have always understood it that way. The implementing regulations demonstrate that the relationships that we are concerned here are banking relationships. It's your customer or depository relationship.
General, does that same provision, 1252F, also affect redressability for standing purposes?
Well, I think that we've obviously analyzed these issues in 2 separate ways, and I think that here, assuming that there were standing, it would have been possible to get a different remedy, like a declaratory judgment, which the state sought in their complaint.
But you don't think that 1252F precludes a declaratory judgment?
That's right. We do not think that so long as the declaratory judgment is not issued in such a way that the court has made clear that it's coercive and, for example, would be backed up by contempt, that would effectively function like an injunction. We're not disputing that litigants would be able to obtain a declaratory judgment in line with Section 1252F1.
So which remedies would it preclude in this case?
So it would preclude the nationwide vacatur that the states obtained here. And the reason for that is because the statute clearly focuses on forms of coercive relief. As the court said in Aleman-Gonzalez last term, it prevents orders that would require DHS officials to take or refrain from taking action to implement the covered INA provisions while a suit proceeds. And that's because Congress's judgment in this area was that only this court should have authority to enter that kind of broad programmatic interference with the operation of the statute while a suit is proceeding. So we think that here, vacatur shares the same feature as an injunction in terms of preventing DHS from being able to implement these covered INA provisions while the litigation runs its course.
Counsel, you have spent quite a bit of your brief talking about the tradition of public accommodations laws. Would you just spend a few minutes or whatever amount of time you can explaining whether there is a similarly long tradition of public accommodations laws applying to speech or expressive conduct?
Well, certainly, Justice Thomas, the history of public accommodation laws shows that when those held themselves open to the public, they were required to serve everybody.
I understand. The complicating factor here, is this is not a hotel, this is not a restaurant, this is not a riverboat or a train. I'm interested in the intersection of public accommodations law and speech.
I think we see some public accommodation law being applied to examples that are speech today, tailors, barbers, et cetera. But what we don't see over the long history of public accommodation laws in this country is people raising First Amendment speech objections to those laws applying to it.
Well, I think that in part depends upon whether or not you're engaging in speech. If you're running a train business or a riverboat business, that's not exactly, doesn't implicate speech. So those are straightforward. I understand that. What I'm interested in is when you are talking about public accommodations laws directly or indirectly regulating speech, is there a tradition of that? Can you point to cases? Can you point to common law treatises, et cetera?
So I think that the historical record is sparse on both sides, but the two things I would say, Justice Thomas, is what we don't see is a history of public accommodation laws carving out speech. They all are laws of general applicability that apply to all those operating a trade to the public. They don't say except those engaged in expressive conduct. And with that framework, we do not see a history of cases where people raise their hand and said it shouldn't apply to me because I'm speaking. And so I think the public accommodations brief on our side in this case sets that out quite nicely, but there is no case from 150 years ago that comes out either way with this exact issue.
Mr. Olson. General, I must say, I think it seems a bit ironic that you're on the other side of a federalism issue. Do you agree with the highly deferential standard that we've been discussing here?
We do.
It would seem to take you out of the equation, or the national government out of the equation.
No, not at all. Justice Thomas, we of course recognize that Congress has its own check under the second half of the Elections Clause, and that remains constant no matter what the states are doing through their state election laws. But as well, with respect to this idea of whether there's an outer federal constitutional standard that could apply here, we agree that that's so, and the court could recognize that kind of constitutional claim. Now, we also agree that that would have to be highly deferential, and I think that that stems from the recognition that to state this kind of claim under the Elections Clause, you would have to be identifying a situation where a state court isn't actually engaged in the process of judicial review. We understand the Elections Clause to pick up through the lawmaking function that ordinary check and balance. And so if a state court is conducting judicial review and is interpreting its state constitution, that presents no fundamental conflict with the Elections Clause itself. So the standard would have to be trying to identify those circumstances when a state court isn't really functioning through the process of ordinary judicial review. And we think that that would be an extraordinary situation, that it's unlikely to arise very often, but there is an outside federal constitutional check that could be applied in this context.
General, I'm sorry.
No, just one last point. It would seem that that would preclude your involvement if the the North Carolina Supreme Court had a decision or rendered a decision that was not generous or less generous or actually antagonistic to an interest that you would normally defend.
We agree that our theory does not depend on the particular state constitutional provision that's being enforced. Of course, there are a panoply of federal laws that apply in this context as well, and so if there was some state constitutional provision like you were positing earlier that would be fundamentally in conflict with the Voting Rights Act, then of course under the Supremacy Clause that provision would have to yield.
Thank you, counsel. Justice Thomas, anything further?
Actually, I don't, but I've been waiting 30 years to ask him a question.
That was good.
Drum roll. You said that this court doesn't normally second-guess state court interpretations of their own constitution. Would you say that in the case of Baker v. Carr?
Yeah, I don't think it was, I think you can declare it unconstitutional, any number of things like that, but to say that they just got their own constitution wrong is just as a matter of interpretation. That is, But
it was purely an interpretation of their own constitution.
And a violation of federal law, right? So.
Well, yeah, I mean, but that's just a way. I mean, you can raise, it's in the end, it was invalidating their interpretation of their redistricting principles.
And Justice Thomas, our only point to you, and it's the same point picking up on Justice Kavanaugh's question to my friend, at page 78 of Bush versus Palm Beach Canvassing Board, you said that the court said that that sovereignty is at its sovereignty was at its apex when you're talking about state constitutions and interpretations by state courts.
Let me ask you this, just as maybe a bit unfair. If the state legislature had been very, very generous to minority voters in their redistricting, and the state Supreme Court said under their state constitution that this violated their own state constitution of North Carolina, would you be making the same argument?
So, yes, I mean, if
you
there
just, and Justice Gorsuch said it seems as though it depends on whose ox is being gored. So I'm changing which ox is being gored.
Yeah, no, we don't think anything turns on the substance of the individual decisions.
But you would still be there making the same argument.
Our point to you, Justice Thomas, is that this court has never second-guessed state court interpretations of their own constitution. And so if there's a general clause and it happens to benefit or hurt minority voters, as Judge Sutton says, that's a process the states deal with. And as I was saying to Justice Alito, there's a special safeguard here, which is the second half of the elections clause, which allows Congress to supplant whatever that errant state court decision is.
So what is it, again, I'd like you to just tell me what is the source of the authority for the state of North Carolina Supreme Court to be involved in a federal election. I understand that there's no disagreement about a state legislator. But this is a federal election, and it's similar to the problem we had with the presidential election in Bush v. Gore.
It's just like Smiley, Your Honor. It's the exact same thing. So there is a federal issue. The North Carolina court is interpreting the elections clauses and powers, and the question is whether or not they have misread it or not. And so I think that's the source of the alleged substantive violation here. I think you're absolutely right. The spirit of your question, for 233 years, this court's never gotten involved and said, hey, we're going to, rove and say the North Carolina court got it wrong or their provision was too abstract for enforcement or anything like that. Rather, this court has always stayed on the sidelines, let the state process unfold, subject to that other part of the trident check, Congress, in the second half of the elections clause.
Justice Alito?